I expressly do not consent to this court's jurisdiction and do not.
Well, then
Any
you are
rights.
not a named party. So if you're not consenting to this court's jurisdiction, sit down. It does call the case of BMC Rio LLC versus Nettie Whitlow and Yolanda Whitlow Tice.
Good morning, Your Honor.
Good morning, sir.
Morning, Your Honor.
Good morning. State your appearance, please.
All right. Ian Redmond, P70599 on behalf of the plaintiff.
And your name, ma'am?
Doshia Banks occupant.
Pardon?
Doshia Banks occupant.
Doshia Banks occupant, Your Honor.
Okay. So you're not Miss Whitlow?
No.
So what is your position in this case as you see it?
If I may, Your Honor.
Okay, good. Go ahead.
Ms. Banks claims to be an occupant of the property. She filed a bankruptcy case listing the property as hers. The bankruptcy stay was lifted, which gave rise to our motion to reopen the case. The order lifting stay I would like to present to the court because it has some interesting language in it, Your Honor, which includes, it is further ordered that the bankruptcy court finding this filing of this petition was part of a scheme to delay, hinder, and defraud BMC REO LLC. Additionally, Your Honor, the bankruptcy court ordered, let me see, notwithstanding Rule 4001A3, a bankruptcy rule,
Right.
creditor VMC REO LLC may execute on its order immediately. The order shall be binding and effective despite any conversion of this bankruptcy case to a case under any other chapter of Title 11 of the United States Bankruptcy Code. Further, that the recording with the appropriate governmental entity of this order shall constitute a bar to refiling any case under any chapter of Title 11 of the United States Code as to the property located at 5779 Pinecrest Estates Drive, Ann Arbor, Michigan. Wow. The property in this case. A debtor in subsequent case under this title may move from relief from this order based upon a change of circumstances or for good cause shown after notice and hearing. Said bar shall be for 2 years from the entry of this order or until such time creditor relinquishes their rights to the property. This order came out June 24th of this year. I have a copy for you.
All right. Thank you.
I will note, Your Honor, that Ms. Banks has filed an appeal of that order in the federal Eastern District of Michigan. That appeal is pending, but the status quo as of right now is that there is no stay, and that order lifting stay holds until such time as the appellate court does something. Additionally, Your Honor.
Yes, go ahead.
Additionally, Your Honor, there is no stay from the appellate court. They have not issued a stay, and in fact, it would be appropriate that there would be a bond placed or an escrow order of some sort, because BMC has been the owner of this property for the past year and does not have access to it. Additionally, Your Honor,
there's more. Go ahead.
There's a lot going on.
Yeah.
Additionally, Your Honor, Ms. Whitlow, who, as far as I know, actually exists, but I don't have any evidence to that effect, has not appeared in any hearings in this court, did not appear for her deposition that she was noticed for in the federal case. And in a federal case, the federal court issued a show cause order to Ms. Whitlow that she had to present certain documents from this court, which she failed to do. Her deadline to do so was, I believe, July 3rd. Let me confirm that. Oh no, July 10th. And she did not supply any of those documents. I can present that show cause order if you would like.
A $1 million Michigan mansion sits empty to its legal owner, but completely occupied by squatters gaming the system. Tonight, we're inside a courtroom where one woman thought sovereign citizen word salad would stop an eviction.
Additionally,
She was dead wrong. Federal bankruptcy records just exposed a calculated scheme. Fake filings, phantom tenants, even a banned bankruptcy preparer, all designed to bleed the bank dry while living rent-free in luxury. The judge has already seen the fraud order that brands this entire operation delay, hinder, and defraud. But the occupant is about to walk in, declare she doesn't consent to the court's jurisdiction, and ignite a showdown no one saw coming. Will her performance stall the eviction? Or is she about to watch her last delay tactic crumble in real time? Next, the most satisfying judicial smackdown you'll see all year.
Has not appeared in.
I don't know that I need that because I'm not.
The reason that I mention all of this, Your Honor,
go ahead,
is that this is $1 million house in Ann Arbor that Ms. Whitlow purchased with a mortgage and less than a year later defaulted. The foreclosure went through, the sale occurred, the redemption period expired, and we came forward to evict. Since then, there have been multiple bankruptcies. Ms. Whitlow filed 2 different bankruptcy cases. A young man who apparently lives in Arizona filed a bankruptcy case and listed this property as his residence. Ms. Banks has filed a bankruptcy case and listed the property as her residence. It should also be noted that Ms. Banks was a bankruptcy preparer and has been forbidden from the bankruptcy court from preparing bankruptcies for anyone other than herself. The order lifting the automatic stay talks about that scheme of fraud. I list all of these things to show that the scheme continues. And that's why we would like to reopen this case, because there is no stay in place. We would like to move forward with an immediate eviction, at most an 11-day vacate. And if for some reason that would not be amenable to the court, we would ask for an escrow order or a bond. On $1 million property, I think it would be reasonable that $10,000 a month rent would be reasonable.
right? Thank you, ma'am.
Yes, Your Honor.
What do you want to tell the court?
Well, just for 60 seconds, and then I wrote something up because I am nervous, quite nervous. But I, Doshia Banks, is respectfully appear specially and conditionally for the sole purpose of protecting federally vested occupancy rights and opposing unlawful state action. I expressly do not consent to this court's jurisdiction and do not.
Well, then you are not a named party. So if you're not consenting to this court's jurisdiction, sit down. You can go because you're not a named party.
I have a lease.
You are not a named party on this. You may have a lease with someone else, and then you can go challenge it. With who?
With Whitlow. Ms. Whitlow.
Then you need to go against Miss Whitlow.
Pardon me?
Then you may need to go against Miss Whitlow. But if you're not consenting to the jurisdiction of this court, you might as well just sit down. You are not a named party. I do not have to hear from you.
Oh, I see. So I need to.
I don't know what you need to do, but.
Well, let me respond.
To what? You're not consenting to the jurisdiction of this court. Why am I hearing from you?
I'm recanting
You're recanting what?
what I just stated.
Which part?
The part that I stated that I'm not, I lost my spot, not consenting to this court's jurisdiction. So I'm going to recant that
So you are consenting to this court's jurisdiction?
at this moment.
Well, no, it doesn't work that way. You don't get to say, well, now it's okay, and then not later say no.
Okay.
You know what? Here's the problem. You've not filed anything with this court.
No.
So I don't know why, on those grounds, why I'm hearing from you.
Okay. If I may, I do have time, I do believe, to go file an answer and counterclaim.
Doya Banks just tried every trick. No jurisdiction, special appearance, recanting on the fly, only to be told to sit down and shut up. She's not even a named defendant, yet she's fighting like the house is already hers. The attorney just dropped receipt after receipt, multiple bogus bankruptcies, a missing owner who ghosts every hearing, and a federal judge who already declared this entire saga fraudulent. Now the real owner, who hasn't seen a dime or set foot inside in over a year, is begging for justice. The occupant still thinks she can talk her way out. But the judge is done playing games. He's about to deliver a verdict that will make her jaw hit the floor. Will he finally order the locks changed today, or give these delay artists one last lifeline? Next, the gavel falls and someone's luxury dream dies in 4K.
I was just led under
An
false
answer and
pretenses
counterclaim to what?
to their complaint for eviction.
You have a lease with, allegedly, with Miss Whitlow.
Correct.
Then that is who you need to pursue it against.
Okay. And
Or whatever the heck you're doing.
well,
Because you don't have, there is no privity of contract to the extent there would be, or relationship as between the plaintiff in this case and you.
okay, I'm not really understanding, but
Well, let me put it a little bit more simpler. If I grant the relief of the plaintiff in this case, and grant an order of a judgment and an order of eviction in 10 days.
okay.
Any claim of your interest in that property, you have to go after the Whitlows, because that's the only person you have a contract with. Allegedly have a contract with.
Okay, no, there is an actual contract.
I don't know that, ma'am.
We've actually been.
I don't know that.
Okay, I know you don't know that, 'cause it's not before you.
Correct.
I see. So basically, the notice of removal that the Whitlows did,
They are not here. I don't know. I have documents that are not, that they filed with this court that are not signed. So I don't have to accept them. She has not appeared before this court, or they have not appeared before this court. And so as far as I'm concerned, any relief they're requesting, I can, and as of right, ought deny, and it should be denied also on the merits of whatever their motion is. But I can deny it because they're not here.
Okay. Again, stating to me, I want to make sure I'm clear that my issue is with the Whitlows, not with VMC.
Ma'am, I am not giving you legal advice.
No, I
You're
don't-
telling me that you have a contract. I do not know that you have a contract, but if you wish to enforce that contract, that's who you're going to have the issue with. You're not going to have the issue with the plaintiff in this case because they have right to own the property.
Okay. All right, Your Honor, I will speak with the Whitlows that I have finally got an understanding of everything. And I will speak with plaintiff's attorney as well and continue to communicate with Remax, who has came by the house several times.
All right. Based upon the representation of counsel, I'm going to grant their motion to reopen this case. I'm going to issue a judgment in the plaintiff's favor for possession with a writ to issue 10 days of my signing. Should the matter be appealed, also contained in that judgment in order, the appeal bond I would set at this time at a rental rate or a rate, and I have looked at the property which is involved in this matter, and it is a significant property. I don't think the $10,000 a month quite does it based upon my calculations. So any appeal bond would be set in the amount of $15,000 per month that would need to be paid to maintain the appeal.
Thank you, Your Honor.
All right.
I will prepare that and present it to you this morning.
Thank you.
May I say something? Our lease payments was not that high at all. I'm not sure what her mortgage payments were. That was not our amount we paid.
Then I'll tell you what. If the Whitlows wish to come and object to my order of $15,000 as an appropriate bond, they may do so. I do not believe that you have standing to object to the court's order. Thank you.
Thank you,
Okay.
Your Honor.
Thank you. Take that,
I know,
and
you didn't write any.
we'll await. I did.
Oh,
No.
no, I don't think so. I don't know if Mr. Fink is ready on.
Mr. Fink, are you ready? But hold on. I'm going to take about a 10-minute break because my head is hurting right this minute. Well, it's not hurting. I mean, I could go on, but I need about 10 minutes after that.
Thank you, Your Honor.
Court.
From the
My
last
issue is
scene,
with
the
Whitlows,
judge
not
just
with
granted immediate
VMC.
possession,
Ma'am, I am not
10
giving you
days,
legal
and the
advice.
sheriff
No, I
can
don't.
drag
Telling me
them
that
out.
you have a contract.
Then
I
he
do
looked
not
at the
know that you have
$1.5 million
contract, but if you
mansion
wish
and
to
set an
enforce that
appeal
contract,
bond at a
that's who
stomach
you're gonna
dropping
have the issue with.
$15,000 a
You're not
month.
gonna have the issue with
The
plaintiff
occupant's
in this
face
case
said it
because
all.
They have right to
Game
own the
over.
property.
This wasn't just an eviction.
Okay.
It was the brutal end of a year-long fraud that fooled no one
Your
except
Honor,
the
I
people
will
running it. Fake
speak with the
bankruptcies,
Whitlows
ghost
that I
owners,
have
sovereign
finally got an
nonsense,
understanding of
none of it
everything,
worked.
and I will
Today,
speak with
the court sent a
plaintiff's
crystal clear
attorney
message.
as well
You don't get
and
to steal a
continue to
mansion with
communicate with
paperwork and
Remax, who
theatrics.
has came
The
by
locks
the
are
house
changing, the
several
bank
times.
is finally getting its house back, and the squatters, they're out of moves, out of time, and about
Based
to
upon
be
the
out on the
representation
street.
of counsel, I'm gonna
Justice
grant
didn't
their
just
motion to
win,
reopen this
it
case. I'm gonna
demolished.
issue a